Good afternoon, everyone. Are you able to hear me?
Yes, I can hear you, Judge. Do I
Thank
need to
you.
log you off on the other one, or you need to be on the
I
other
always
device?
keep that as a backup, Miss Lewis. You can never be
Okay,
but so prepared. I'm on twice, just in the
okay.
event of any internet connectivity issues. Everyone, today is February the 16th of 2022. I'm Judge Melanie Williams. This is the state expedited accusations calendar in the state court of Fulton County. This calendar is for those individuals who have been recently arrested, but the cases have already been formally accused and bound over to state court. I want to advise all participants that this proceeding is being broadcast over the internet. That means that any member of the public can log on and watch this proceeding. It is also being recorded. To all defendants on the screen, you have an absolute right to remain silent. Anything you say can and will be used against you. You also have a right to an attorney at this proceeding.
Judge,
What
can you
is
hold on
my
for a
essay?
second? Excuse me, Judge. I'm having trouble, technical difficulty with my litigation manager. Can you hold on 1 second if I can try to get her on?
Oh, Miss Champion is not on the line.
No.
Okay,
Okay, give me 1
let's
second.
hold for Miss Champion to get in
Okay.
because she'll need to be a part of this proceeding, and I also need to know my reset date from her. In the meantime, are there any positions at the jail that we already know will be reset today? Either courtroom 2 or South Annex?
Reginald Jones.
Oh, before we're gonna hold for a moment. We're waiting for my litigation manager to join.
That's a reset.
Oh, Reginald Jones is a reset. Okay, thank you. What position is that?
I think 6.
Okay.
Five.
Five.
And also Alex Griffin, MH reset. And Alex Griffin as well, MH reset.
Number 3.
Thank you. Thank you. I appreciate that. We'll be in a very brief hold until Miss Champion can join us.
Did you get my email?
I did. Thank you, Mr. Howard.
Okay.
I saw a name on there I did not recognize, though, that I don't think is on this calendar. Last name Kelly.
She got upgraded.
Okay.
So she's gonna tell me.
Okay. We'll hold so Miss Lewis or Miss Champion is able to get on the line.
All right, Judge, she's coming in on now. She's having difficulty. She should be logging on now. And I would just inform 5 and 3 are gonna be resets.
Yes, and I see Miss Champion's now on the line, so we'll take the first position at the jail.
Position number 1, Ms. Askew at the South Annex, Your Honor.
Good afternoon, how are you? Are you Nicole Askew?
Yes.
Okay, Ms. Askew, your case is 22 CR 000793E, in which you're charged with 1 count of battery family violence with an offense date of December the 19th of 2021. You've heard me advise you of your constitutional rights to an attorney and to remain silent. Do you object to a video hearing today?
No.
And who represents Ms. Askew? Is Ms. Askew's counsel on the line?
Sarah Armstrong is representing her.
Okay. I don't see Ms. Armstrong on this Zoom conference.
She's coming on now, Judge. She just logged in. She should be
Okay.
popping up shortly.
Okay,
Thank you.
I probably have to click over a couple positions. Okay, I see Ms. Armstrong is connecting to audio. Ms. Armstrong, you're present on the Zoom conference and able to hear me?
Yes, Judge, I apologize for the late sign and I just now got the Zoom link and I appreciate your patience.
All right, thank you. Ms. Askew, do you object to Ms. Armstrong assisting you by video or to me conducting this hearing today by video?
No.
All right, thank you. Before I begin, Ms. Howard, I see she's recommended this is first arrest.
Oh, it's a second.
Okay,
2019 ag assault. It was dismissed
okay.
out of
Thank you.
Gwinnett County.
Okay. All right, whose case is this for the state?
It's my case, Your Honor. Alexis Guidry.
It's good to see you, Ms. Guidry. What is the state's recommendation for her bond?
Your Honor, we're recommending a $5,000 surety bond, no further contact with Michael Gully, a stay away from 925 Canterbury Lane, Northeast Atlanta, 1-day anger awareness, and no alcohol, drugs, or weapons. In this case, it was learned that the defendant had punched Mr. Michael Gully in the mouth due to an argument in regard to their son. Mr. Gully sustained a busted lip, and officers observed blood coming from his mouth. Your Honor, due to that aggravated assault that pretrial stated, that is the same victim. Although we do understand that it was dismissed, we are concerned for his safety, given that this is the second time that they have been involved in a physical dispute. So that's why we're asking for the stated recommendation.
All right. And can you give me that stay away address again?
It's 925 Canterbury Lane, Northeast in Atlanta.
That's a home or a business?
It's a home, it's an apartment. I have the apartment number as well. It's 1035.
Okay, thank you.
You're welcome.
All right, Ms. Armstrong?
Judge, thank you. Could I once again hear the arrest date for that ag assault that got dismissed?
2019, I believe. Is there a more specific date?
I just want to know the year. Thank you. I did speak with Mr. Gully and of course, Ms. Askew. The state's theory of the case is simply not what happened. Mr. Gully can tell you himself, he is a part of the court session right now, that this did not occur the way that the police reported it, nor did it occurring to Ms. Askew. This was a verbal altercation that turned into alleged mutual combat. Ms. Askew actually left the home to cool down. She did the responsible thing by leaving. And it appears that she's being penalized for leaving as being seen as the initial aggressor. Mr. Gully does not want this case to be prosecuted. He is adamant about that. My client does not qualify for a representation. I have advised them to reach out to a private attorney and given them a recommendation to do so. But Mr. Gully does not want to participate in the prosecution of Ms. Askew. Moreover, she does work for a major university in the Metro Atlanta area. And Mr. Gully is prepared to speak to your honor should you want to hear from him.
Okay, and Ms. Armstrong, I'm going to hear from Mr. Gully, but I didn't hear your recommendation. You're requesting what?
We're requesting a signature bond in this matter. She has no criminal convictions of any kind. The aggravated assault got dismissed. Mr. Gully is not in fear of his safety. We're asking for not to impose a stay away provision. We're asking for no further violent contact, if any. Restrictions on their contact.
Okay, thank you. At this time, Mr. Gully, I see you present on the Zoom conference. If you would like to make a statement, I need you to unmute.
Yes, ma'am. Thank you, Your Honor.
Before you begin, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, what would you like to tell the court today?
Well, I'm not in fear. I'm not in fear for my safety at all. I love my wife. My wife loves me. And we had an argument that day. It got out of hand as far as me verbally assaulting her, me saying things to her. And I talk with my hands kind of, as you can see now. And I think, matter of fact, I know she just felt like I was about to come at her. If anybody was wrong, it was me, not her.
Okay.
Not her. We've worked on our marriage. We've talked to our pastor, Reverend Mays. We're in a good place. We're in a very good place. She's about to start a new job at Morehouse. My career is, we're in a good place. We're in a good place. I'm not in fear for my safety. I just want my wife home.
All right, thank you, Mr. Gully. I appreciate you making a statement before the court. Is there anything further from either the state or the defense before I issue my ruling?
Yes, Your Honor. May I ask Mr. Gully a quick question?
It
Yes,
depends. You would need to very limit the scope of the questioning as he's not here to be a fact witness, but go ahead, Ms. Guidry. I will allow some very limited questions.
Okay, Mr. Gully, in regards to the Gwinnett case, the aggravated assault, did you ask for it to be dismissed?
Yes, ma'am.
Okay, again, Your Honor, as stated, we're asking for the stated recommendations. We understand that the case was dismissed. However, I'm sure Your Honor is aware of the cycles of violence, and this is a classic case of that matter.
All right, thank you. Based upon the information before me at this time, Ms. Askew Gully is going to receive a $6,000 signature bond through pretrial services. She is to have no alcohol, drugs, or weapons as a condition of this. She must also complete a one-day anger awareness course. Are there any further questions from either party at this time?
Did you order no further violent contact?
I'm sorry, oh, and no violent contact with the victim. No further violent contact. All right,
Okay.
best of luck to you, Ms. Askew Gully. I believe we're
Next.
moving on.
Next, we have position 11, Ms. Mccluster.
Okay, good afternoon, Ms. Mccluster. Your case is 22 CR 0008000E, in which you're charged with 1 count of cruelty to children in the 3rd degree, 1 count of battery, 1 count of, actually 1, 2, 3, 4, 5 counts of cruelty to children in the 3rd degree, and 1 count of battery, each with offense dates of August the 22nd of 2021. You've heard me advise you of your constitutional rights to an attorney and to remain silent. Do you have any objection to a video hearing today?
No.
Ms. Armstrong, do you represent her as well?
I do, Judge.
And do you object to Ms. Armstrong assisting you by video?
No.
Thank you. Mr. Howard?
Second arrest. Last was 05. Possession of crack cocaine conviction. That's it.
Okay, thank you. And whose case is this for the state? Is it you again, Ms. Guidry?
Yes, Your Honor.
All right, your recommendation.
Give me 1 second. Okay. The state is recommending a $5,000 surety bond for the battery, and for the 5 counts of cruelty, 100 for each count, making it a total of $5,500. No further contact with LaShandra, that is LASHUNDRIA, favors or her children. A stay away from the incident location, which is 984 Hart Street, Atlanta. And 1 day anger awareness, and no alcohol, drugs, or weapons. Your Honor, in this case, officers responded to the incident location. Ms. Favors was in her vehicle when the defendant walked up to her vehicle, opened her door, and began hitting Ms. Favors repeatedly. She stated during the incident one of her children was pushed. A neighbor who witnessed the incident stated that the attack was very ugly and that the defendant did not have to attack Ms. Favors in front of her children. As the witness stated, Ms. Favors' 5 children were present at the time of the incident. The defendant knows Ms. Favors due to the defendant being the girlfriend of Ms. Favors' father of her children. Again, Your Honor, due to the nature of this crime and that she committed this act in the presence of 5 children and allegedly pushed one of the children, we're concerned for Ms. Favors' safety and her children. That's why we're asking for the stated recommendation.
Okay, thank you. Ms. Armstrong?
Judge, we're asking Your Honor to consider a signature bond on each of these counts. If not a signature bond, we're asking for a bond no more than $1,000 and still a signature bond on the alleged cruelty charges. Ms. Mccluster is the fiance of the man who Ms. Favors used to date, and they do share children. Ms. Favors, the alleged victim, invited my client to her home to discuss an issue about childcare concerning going to daycare, and that one of the children had a rash, and Ms. Mccluster was concerned that her children might get the rash that was on Ms. Favors' kids. So once again, Ms. Favors invites my client over to her home. The alleged victim was in her car. The alleged victim actually exited her car to attack my client. And even after the incident, which was alleged to have occurred in August, the alleged victim's children have been in the care of Ms. Mccluster, because once again, there is a relationship here. They should have to share child support between the fiance, my client, and Ms. Favors. So it is baffling to me that Ms. Favors would be in so fear of her safety that she would actually allow her own children to be in the care of my client. My client does not have a criminal history except for a 2005 drug conviction. She does not have any violent convictions or allegations. She's been in Atlanta her entire life, and she takes care of 8 children, including the children of the alleged victim. That is why we're asking Your Honor to consider a signature bond. She needs to be out working. She does work in environmental services at a major hospital in the area. She provides support to the sick essentially, because she does clean the room of people who have COVID. So we need her out supporting her family, including the alleged victim's children.
All right, thank you, Ms. Armstrong. At this time, I am going to rule that Ms. Mccluster is going to receive a $2,500 surety bond, broken down as follows. It'll be $2,000 on the battery and $100 on each cruelty charge to reach that total of $2,500. She is to have no further contact with the victim, last name Favors, and she must stay away from the incident location. She is to have no weapons, drugs, or alcohol as a condition of this bond. Her case will be reset to the SAP calendar on March the 1st of 2022, where this can be revisited at that time. Is
Judge, I
anything
think
further from
somebody-
either party?
Excuse me, is the victim on the line for this case? Because she's typing stuff in to everybody on the iPhone. Person is on iPhone. Can you identify yourself?
Hold one moment. All right, I don't believe that the the victim last name Favors present on the screen and would like to make a statement. Okay, Ms. Favors, are you present? Are you the iPhone? Okay, hearing none, we're going to conclude Ms. Mccluster's case at this time.
Okay.
Bond will remain as set. All right, best of luck to you, Ms. Mccluster. We can move to the next case.
Okay, I have a question, Your Honor. Ms. Luckett she has a felony case, she's here. I don't know what position she will be in.
What's her name?
Luckett, Luckett.
I don't think she appears on this calendar. No, she's not on my calendar.
She's not.
Your
Okay.
Honor, if I can get a first name, I can look into it while you're continuing with court.
That would be great. What's her first name?
ZHANTIYA.
And is there another position at the South Annex, or will that conclude the business at the South Annex?
No, we're not finished. I have Ms. Streeter, but right now Ms. Watson Cafe is talking to Ms. Jordan Megan, who is a conflict. So I
Okay.
have two conflicts.
Okay, so both of those are conflict cases. Are we able to go to a case at courtroom 2 temporarily until the South Annex is ready again?
Thank you for coming back to me, Your Honor.
Thank you.
Yeah, this is number 14.
Okay. Okay, can you pronounce your name for me?
Giovanni Screen.
Okay, your case is 22 CR 000-799J, in which you're charged with 1 count of disorderly conduct with an offense date of February the 12th of 2022. You've heard me advise you of your right to remain silent and your right to counsel. Do you object to a video hearing today?
No.
Okay. I'm sorry, speak very loudly so we can hear you.
I don't know what, I mean, what do you say? Don't say no. Okay, no, I'm sorry.
Okay, thank you. What I'm asking you essentially is, I'm not there with you and your attorney is not there with you either. And I'm making sure that you don't object to us proceeding by video. Ms. Kim, do you represent this defendant?
Yes, Your Honor.
And you can, as you see, your attorney's on the screen too. I'm just making sure that that's okay with you.
Yes, ma'am.
Okay, I appreciate that. Mr. Howard, can I have the history, please?
21 total. Last arrest was back in May. Probation violation for theft by receiving, driving without a valid license. March 2020, possession of cocaine, criminal trespass arrest. 2019, possession of cocaine arrest. 2019 probation violations, it was convictions. 2018 probation violation, underlying charge was battery. 2018 failure to appear, battery. Probation violation for theft by receiving, driving without a valid license. FTA for forgery in the first degree. 2017 fade to appears. 2017 another fade to appear. Possession of cocaine, giving false information. 2016 probation violation. Underlying charges: ag assault, false imprisonment. 2016 battery conviction.
Thank
2014.
you.
Okay.
I think that's good. I think I have a good picture. Thank you. Is this your case, Ms. Guidry?
Yes, it is.
All right, and what is the state's recommendation?
Your Honor, she currently has a $225.04 surety bond. This is a bond over case. We're asking for a $2,000 surety bond, a stay away from 5015 Old National Highway, which is Old National Nail and Spa, and no alcohol, drugs, or weapons. In this case, they observed the defendant yelling and acting in a violent and tumultuous manner at the Old National Nail and Spa. Officers detained her and spoke with Danny Smith, who stated that the defendant was yelling at the nail tech and acting in a violent manner. Ms. Smith stated that she was in fear of the defendant due to her behavior. Your Honor, as pretrial stated, the defendant has numerous failure to appears, 2 from 2018, 4 from 2017, and 1 in 2014, many probation violations, and 2 open cases for possession of cocaine again in 2020, and criminal trespass. So we're concerned that she's a flight risk and also a risk of reoffending given her criminal history. She also has convictions 2020 for criminal trespass, false imprisonment 2015, aggravated assault, strangulation 2015, a battery 2015, and another battery out of 2018. So we're gravely concerned for the safety of the community given her criminal history. So that's why we're asking for the stated recommendation.
Thank you, Ms. Guidry. Ms. Kim.
Yes, Your Honor. Mrs. Green is 25 years old, and she is a main caregiver for her mother, who has a lung cancer, and her mother really needs her care. So we would like to request for a lower bond, or actually change $225 to signature bond, because she could not get out of the jail since she doesn't even have a $225. There's no way that she's gonna pay for $2,000 that state is requesting right now. And she has been out of probation for about 2 years. That's what she was telling me. And she's not a flight risk. She was born and raised here in Georgia. She's married right now, and she's working. She has been working for about 3 years, and she would like to keep her job so that way she can pay for all those, if there's any bond or anything. Not only that, absolutely taking care of her mother. So we would like to request for signature bond, Your Honor. Thank you.
Thank you, Ms. Kim. What is the amount of the current bond again, Ms. Guidry or Ms. Kim?
$225.04. Yes.
And that's a cash bond?
Surety bond.
All right, at this time, her bond will remain as set. And Ms. Stream must also stay away from the Old National Nail and Spa at 5015 Old National Highway. Her case will be reset to the SAP calendar on March 1st. Is there anything further from either party?
Nothing further.
Nothing further, Your Honor. Thank you.
All right, best of luck to you. And we can move to the next position.
This is number 4.
All right, are you Christopher Gunn?
Yes, ma'am.
Judge, I'm here on that case. My name is Attorney Kevin Fisher. I'm representing Mr. Gunn.
Thank you. Mr. Gunn, your case is 22 CR 0007995D, in which you're charged with 1 count of duty of vehicle emerging from the alley or building, and homicide by vehicle in the 2nd degree misdemeanor, with offense dates of February the 14th of 2022. You heard me advise you of your right to remain silent and your right to an attorney. Mr. Fisher is present on this Zoom conference with me to represent you, and I'm appearing by video. Do you object to this video hearing today?
No, ma'am.
All right, thank you. I'm going to hear first from Mr. Howard, who says that he is recommended. Is that correct?
Yes. 3rd arrest. Last arrest was 2008 for battery. It was DWAP. And before that was 1999 assault out of Alabama. That's
Okay,
it.
thank you. All right, Ms. Guidry, is this your case as well?
Yeah, sure, there it is.
And the state's recommendation?
We're recommending a $10,500 total surety, $10,000 for the homicide by vehicle in second degree, and $500 for the duty of vehicle emerging. And no alcohol, drugs, or weapons. Your Honor, in this case, on February 14th, officers responded to 2220 Campbellton Road, Atlanta, which is the YMCA, due to a pedestrian being struck. Upon officer arrival, Mr. Jerry Hood was lying in the roadway and had been pronounced deceased. They spoke to the defendant, who stated that he was exiting the driveway of the location and turning right. After turning right, a passing motorist got his attention to advise him that Mr. Hood was under his vehicle. Upon reviewing the footage, it shows that the truck that the defendant was driving stopped in the driveway. After traffic passes, the defendant turns right onto Campbellton Road. Based on the video, Mr. Hood was approaching the defendant's right side of the sidewalk. Officers stated that based on the height of the truck and the incline of the driveway, it is possible that the defendant did not see the pedestrian. Your Honor, we're concerned mainly here that there is a deceased victim, Your Honor. We do understand that he may not be a flight risk, but in cases as such as this, it is gravely concerned, and we're concerned for the community. We do understand that he doesn't have any convictions. However, we would like to recite his citations. He does have an improper lane from 2009 and a failure to obey stop signs from 2006. Again, this is a case where there is a victim who's deceased. And as you know, sometimes in cases where the victim is deceased, that defendants do not show up. So we want to ensure that he will show up. So that's why we're asking for the stated recommendation.
Thank you. At this time, before I go to Mr. Fisher, is any member of the victim's family present on this Zoom conference that would like to make a statement at this time? I am sounding for any member of the victim's family at this time. Hearing and seeing none, Mr. Fisher, you can give me your recommendation for Mr. Gunn's bond.
Thank you, Judge. So this is a tragedy in this case. This was just an accident, Your Honor. There was no drugs, there was no alcohol involved. We're not sure about the deceased, but I know that my client, Mr. Gunn, was not under the influence. There was no underlying offense. Mr. Gunn has got a home in Georgia. He has a child here. He has a very good job with waste management. He's gainfully employed. They hold him in an extraordinarily high regard. The date that this took place was the 2-year anniversary of his daughter being murdered. That case had made the headlines and the news, and that trial is happening in South Georgia. So there was a lot going on in my client's mind that day. And then when this happened, it was horrific for him. He has been extraordinarily remorseful with me. When I met with him and the police yesterday, he voluntarily came to the police department. The officer that took him in even contacted the judge that was on duty yesterday to try to see if an OR bond or signature bond could be arranged because of the type of person that Mr. Gunn is. He is not a flight risk, Your Honor. He has no reason to go anywhere other than to stay employed and be with his family when this trial begins. He does have one son who's, I believe, in his 20s that lives with him. He has a girlfriend that has a very good job with the government. Those 2 traffic violations were so long ago, I'm not sure how they're relevant. But we are asking for a signature bond on both, Your Honor. He's not going to commit any more crimes. He just wants to continue to work and pray for the other family and pray for himself to get through this, because this is it's just an accident. There was no intent to harm anyone in this particular case. In addition, when I was with the police department and speaking with the detective and the officer involved, he also said that this is just one of those crappy cases, that you have empathy for the person who's involved versus a case where there is a DUI with a vehicle homicide, which has a different type of reaction. But this is a very sad case, and we would like Your Honor to consider an OR bond on both And I don't believe that it's necessary for my client to abstain from drugs and alcohol for no reason when this drugs and alcohol wasn't even a factor. And he's got no prior DUIs.
All right, thank you. Mrs. Fisher, Ms. Guidry, I want to revisit the special conditions you were asking for. You asked for no alcohol, drugs, or weapons. Those were the only conditions that were requested by the state?
Yes, we're not asking for no driving because I don't see anything on his record that would state that his license is suspended or revoked. Just
I
the
think
no alcohol, drugs, and weapons.
Yeah, and just to reiterate, it was alcohol, drugs, and weapons, not no driving, but I don't, again, my client doesn't have any prior DUIs and doesn't have a problem with alcohol, and there was no alcohol or drugs that had anything to do with this case or firearms.
And again, Your Honor, we just want to ensure the safety of the defendant as well, Your Honor. And again, we do understand that this is a tragedy. He doesn't have any convictions. However, given the fact that there was a homicide and given the fact that people in passing cars had to stop him to inform him that someone was under his car is gravely concerning, Your Honor. So that's why we're asking for that bond.
All right, I think
In Your Honor, in response to that, he's also driving.
very briefly, Mr. Fisher, go ahead.
He's also driving a, I don't know what the size of it, but it's a very large garbage truck. It's not a normal vehicle, so it is very difficult to hear what's happening in the vehicle.
This happened in the course of his employment? I'm
Yes, ma'am.
assuming.
Yes.
Okay.
Yes. And the attorneys for his employee were on the scene immediately. That's how high of regard they have for him.
All right. Any other response, Ms. Guidry?
Nothing further.
All right, I am gonna do a split bond here. I'm gonna send the duty of driving the vehicle or emerging from the charge one. It's not really written clearly on my calendar. I'm gonna send that one through pretrial services as a signature bond for $5,000. There will be no special conditions as part of that split bond. Then he, on the homicide misdemeanor, he will receive a $5,000 surety bond. And I agree with Mr. Fisher. I'm not going to impose the no weapons, drugs, or alcohol at this time. All right, is there anything further from either party?
Nothing further.
Nothing further, Judge. I'll go ahead and contact the family to get this lined up.
All right, best of luck to you, Mr. Gunn.
Thank you, Judge, for your time. Thank you, Ms. Goodry.
All right,
Thank you.
all right. We can move to the next position.
Number 2, Mr. Bowden.
All right, good.
Oh, my
Yes.
apologies, Your Honor. I do have some additional information on the Luckett case. That's the case that did not appear on the calendar. However, there was
Yes.
an inmate in the jail.
Yes,
That-
ma'am.
The defendant in that case was charged with 4 counts of cruelty to children in the first degree, which is felony charges. So that it would have gone to felony first appearance. I have reached out to the attorney who handles felony first appearance and just am awaiting the announcement. I will say in cases where they may have tried to downgrade the charges or do something else, first appearance is still held on the case and then the case is transferred accordingly.
All right.
So there should be no reason we should be hearing that case today.
All right, thank you so much, Ms. Falk, for looking into that for us. If the South Annex is not, I don't believe South Annex is ready, but we'll make that same announcement when Officer Bogle returns. All right, this is are you Michael Bowden?
Yes, ma'am.
Okay, Mr. Bowden, your case is 22 CR 0007928, and which you're charged with 1 count of simple battery family violence with an offense date of September the 12th of 2021. You've heard me advise of your constitutional rights. Do you object to this video hearing today?
No.
Do you object to, Ms. Armstrong, is this your case, I'm assuming?
Yes, Judge.
Do you object to Ms. Armstrong assisting you by video?
No.
Okay, I appreciate that. All right, Mr. Howard?
His 4th arrest. Last was back in September. Possession of a Schedule 1 controlled substance. 2 counts. 1 count possession of drug-related object. Sale of marijuana out of Douglasville. That appears to be open. May 2021, misdemeanor possession of marijuana out of Clayton County. June 2020, inciting to riot. That was dismissed after pretrial diversion. So he got the open drug cases.
Okay,
So,
all right. Ms. Gidry,
Yes, Your Honor, we're recommending a $2,500 surety bond, no further contact with Isis Williams, who is on the line, a stay away from 2585 Beeler, Beeler Drive, Southwest Atlanta, 1-day anger awareness, third-party contact with any children, and no alcohol, drugs, or weapons. Your Honor, in this case, officers responded to the location. They spoke with Isis Williams, who stated that she was in a dispute with the defendant, who's the father of her children, when he pushed her in the laundry room. Ms. Williams also informed the officer that the incidents occurs often. Incidents of this nature occurs often. She also stated that at the time that the defendant does not live with her. So, Your Honor, in this case, they do have children together. We're asking for a $2,500 surety given the nature of the offense and given that Ms. Isis stated that incidents like this does occur often. So we're concerned for her safety and that there is a risk of reoffending and intimidation of the witness.
all right, thank you, Ms. Gidry. At this time, I am going to sound for the victim, last name Williams. Ms. Williams, if you would like to make a statement at this time, please turn on your camera and unmute your screen. You are not required to make a statement. However, you are free to do so if you would like to. Do you wish to make a statement?
Yes, ma'am.
Okay, please raise your right hand before you begin. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes, ma'am.
All right, what would you like to tell the court?
I don't recall stating that that happened multiple times. When the officer spoke with me, I did explain that we argue and fuss a lot, but he has never put his hands on me.
Okay. Thank you, Ms. Williams, for that
You're
statement.
welcome.
All right, Ms. Armstrong.
Thank you, Judge. First, I want to move to dismiss this matter. As Ms. Williams said, this did not happen the way that the police reported to happen. Also, the state just testified that based on the police report that the defendant actually did not live with the alleged victim at the time. Therefore, there's no way that they'd be able to prove the family violence component of the simple battery allegation. Your Honor is not willing to dismiss. We would ask for a signature bond in consideration of the factors I just stated. And if Your Honor is not inclined for a signature bond, we are asking for a bond no more than $1,000, given the very weak factual basis underlying this allegation. When I spoke with Ms. Williams, who was emphatic that she did want to speak with me in support of my client, that she did not call the police. She believes that a neighbor possibly called because they were arguing in the laundry room, but it was just a verbal argument. It was not physical. And my client does work in a warehouse in the Atlanta area. He's not a risk of evading coming to court. He will come to court when he's supposed to. And we are asking for you to consider a signature bond once again. No violent convictions. He has just a couple of drug arrests, but he's not convicted of any violent offenses.
Ms. Armstrong, I want to clarify one point. Are you saying that Mr. Bowden does not live with the with Ms. Williams?
But I'm so sorry for talking over you. I referenced that because that is what the prosecution just said, that based on the testimony based on the police report, the alleged victim stated they do not live together.
That is correct, Your Honor. However, he is the father of her children. So that is enough for family violence.
The stay away address, what is that stay away? What kind of location, whose home is that stay away address?
Miss Williams, is that address your home address?
Yes, ma'am.
Are you the leaseholder of that address?
Yes, ma'am.
Okay. So, Your Honor, that's her address.
All right. All right, I think I understand the situation clearly, but because I did allow additional statements, Ms. Armstrong, would you like to make any further statements, or Ms. Gidry, any response?
No, Judge.
Nothing further.
All right, at this time, what I'm going to do is Mr. Bowden is going to receive $1,000 surety bond. I'm going to say that he's to have no further contact with the victim, last name Williams, and he is to stay away from the address on Beeler Drive. He will be reset to the SAP calendar on March the 1st, where contact and stay away could be revisited at that time. For now, he is to arrange the transport of the children through a third party, and he is also to have no alcohol, drugs, or weapons as a condition of his bond. All right, is there anything further from either party?
Nothing further.
All right, hearing nothing from the state or the defense, best of luck to you, Mr. Bowden.
Thank you.
Who do we have next?
Number 7, Mr. Jordan.
Sorry,
Okay.
56 or 7?
I think we said 7. Are you, is 7, are you Megan Jordan?
Dwight Jordan.
She's right here, Your Honor, at the South Annex. That's the conflict.
Okay,
And after that, I have the other conflict, Ms. Streeter.
We have 2 Jordans on the counter today, so everybody's getting kind of confused.
okay,
Position 6 and 7, they both have the same last name.
okay, I understand. Are we going to 7 now, or are we going to 6?
I guess 6 then.
Okay. All right, are you Megan Jordan?
Yes, ma'am.
Okay, Mr. In your case is 22 CR 0007948, and what you're charged with simple battery family violence with an offense date of February the 15th of 2022. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney, and Ms. Watson Cafe is present and available to assist you with this proceeding. Do you object to a video hearing, or do your attorney appearing by video to assist you today?
No, ma'am.
Okay, thank you, Mr. Howard.
The first arrest. She's a resident of Bryson City, North Carolina.
Okay. Was she recommended? I did not see her on your list. I'm assuming so.
I think it was a jail recommendation.
Recommended to the jail. Okay, thank you. All right, Ms. Guidry.
Yes, Your Honor. So we're recommending a $2,500 surety bond, no further contact with Schuler, SHULER Jordan, a stay away from 7165 Avalon Boulevard, Alpharetta, and 1-day anger awareness, and no alcohol, drugs, or weapons. Your Honor, in this case, officers responded to the address. The defendant stated that she and Schuler Jordan, who is her husband, were having a verbal dispute when the defendant became enraged due to Mr. Jordan bringing his new girlfriend over. She struck him on the right ear with an open hand. Mr. Jordan's ear was red, but officers could not determine if Mr. Jordan's ear was naturally that color or if it was due to the slap. We did speak to the victim. He stated that they are married, however, they are in the process of getting a divorce. And he also stated that he is fearful of the defendant and he does not want contact. Your Honor, given the fact that the victim is concerned for his safety, we're asking for the stated recommendation.
All right, thank you.
You're welcome.
All right, Ms. Watson Cafe, do I see you on the screen? Oh, now I see you. Thank you. I did not see you for a moment. Good afternoon. How are you? Good to see you on the screen.
Would like to start by saying that client vehemently denies these allegations. My client arrived at the location to pick up the rest of her items. When she arrived there, there was an argument ensued. The victim's mother actually called, I'm sorry, not the victim's mother, Miss Jordan's mom is the one that actually called the police because they were fearful of the victim striking Miss Jordan. That being stated, Your Honor, as Mr. Howard has already stated, she has absolutely zero history. She's 26 years old. She resided in Georgia for 4 years. She is a resident of North Carolina, but I do have good contact for her. I'm sorry, you're
Resident of Georgia.
You're currently residing in North Carolina though with your mom?
Just for the past week, but my license is still Georgia residency.
Okay, she's currently residing in North Carolina, Your Honor, with her mom. She has a high school education. She has completed some college. She has a real estate license and a nail tech. She's currently unemployed, but she was previously employed as a nail tech in Alpharetta. She is fine with the stay away order. She does not want to have contact with the alleged victim in this case. Based on all of that, Your Honor, we would ask for a signature bond. She, again, doesn't have any history. She also is currently unemployed, has been unemployed for several months. So she just doesn't have the much of a financial reach at this time to pay a high bond. If Your Honor is not amendable to a signature bond, we would ask for a bond, a surety bond in an amount no more than $500. Thank you, Your Honor.
Thank you. At this time, Ms. Jordan is going to receive a $5,000 signature bond through the jail. She is to have no further contact with the victim, last name Jordan. She is to stay away from the address on Avalon Boulevard. She is to have no weapons, drugs, or alcohol, and she is to complete a one-day anger awareness course. I believe that I've addressed all those conditions. Is there anything further from either the state or the defense?
Nothing further.
Nothing further, Your Honor. Thank you.
Okay. Best of luck to you, Ms. Jordan.
Thank you.
Next is position 15, Ms. Streeter.
Your Honor, just a really quick question. I understand that you ordered a signature bond through the jail on Miss Jordan as well as one-day anger awareness.
I did. I know that's not traditional, but I'm hoping she'll be able to find some, as I
Okay.
believe that's necessary.
Right. I was just checking because I know it normally goes through pretrial.
Through pretrial
Thank you.
services because of her, because she doesn't live here. I figured that will be a challenge, but I'm hoping she'll be able to be creative and use her resources.
Thank you, Your
We'll
Honor,
make
for the
sure that she
clarification.
gets that done, Your Honor.
I'm sorry, Ms. White.
I said, we'll make sure that she gets that done, Your Honor.
I appreciate, I'm sure you'll help her find a great place to take that class.
Yes, Your Honor.
All right, Ms. Streeter, are you Stephanie Streeter?
Yes, ma'am.
Okay, Ms. Streeter, your case is 22 CR 00789A, in which you're charged with one count of battery family violence with an offense date of September the 25th of 2021. You've heard me advise you of your rights. Do you object to a video hearing or to Ms. Watson Cafe assisting you by video?
No, ma'am.
All right, thank you. Mr. Howard?
So fifth arrest. Last arrest was January 2021. No, I'm sorry. Last arrest was in June. Hold on. Yes, in California. It was for cruelty to elderly, driving without a license. She had a 2012 arrest in California for suspended license. As far as Georgia arrest, she was arrested January 2021, battery family violence. Same victim, and that's an open pretrial case. It went to Superior Court, but they transferred it back to state court.
Okay. All right, thank you. Is Ms. Arnold, is this your case?
Yes, Your Honor. Good afternoon.
Good afternoon, good to see you, Ms. Arnold. What is the state's recommendation?
The state's recommendation is $6,000 surety bond. We're asking for no further contact with Xavier Franklin. Xavier spelled Xavier, Franklin spelled traditionally. A stay away from 62 Harwell Road. Harwell spelled Harwell, Northwest in Atlanta. A one-day anger awareness and no drugs, alcohol, or weapons. Your Honor, this incident happened on September 25th, 2021 at that Harwell Road location. Mr. Xavier Franklin advised that he and his girlfriend, the defendant in this case, were drinking, and after they had came home, they got into an argument, which started over Mr. Franklin accidentally bumping into the defendant. That argument turned physical when the defendant decided that she would pull Mr. Franklin's hair. In fact, the defendant pulled his hair hard enough that she actually ripped the hair right from his scalp. When officers arrived, they were able to see two of Mr. Franklin's dreadlocks lying on the table. Your Honor, we believe the defendant will reoffend. She has a battery conviction out of California from 2002. And more importantly, as pretrial has already mentioned, she has an open case against this same victim. Case number 21 CP 197133 for battery family violence. And in that case, she was ordered to stay away from this same incident location and to have no further contact with Mr. Franklin as a condition of that bond. She had a unsecured judicial release, excuse me, through pretrial. And we're back here again today, Your Honor, for another battery family violence. So
I'm
that
sorry, that's my residence. That's my home. It's not his
Miss
home.
Streeter, don't say anything. Let Miss
Okay.
Watson Cafe represent you. I don't want that. I don't want you to
Okay,
inadvertently say something. Okay,
Sorry.
continue, Miss Arnold.
Yes, Your Honor. So that is the reason that we are requesting the $6,000 surety with the conditions as stated. Thank you.
All right, thank you. Ms. Watson Cafe, and I'm sure that there's some points of clarity that we'll need regarding her residence based on her last statement.
Quick question. Does anyone have the case number that's currently open, the incident date on that by any chance?
Yeah, the incident date was January 28th, 2021.
Okay. Thank you. All right. I guess we can start with the address, Your Honor. It's my understanding that that is her address and not the alleged victim's address. She lives there with her minor child, who she shares with the alleged victim. She's 10 years old, and she's currently staying with a neighbor because of this recent arrest. My understanding, speaking to Ms. Streeter, is that first of all, the allegations are denied as stated in the warrant application. I do believe that it's important to note that Mr. Franklin left that night and specifically informed the officers that he did not want to press charges, which is also stated in the warrant application. That being said, my understanding, speaking to Ms. Streeter, there was a no contact order. Mr. Franklin was allowed to come back to the residence one time to pick up his items. At that time, he did come back to pick up the items. An argument ensued. Ms. Streeter vehemently denies that she attacked Mr. Franklin at that time. I understand that there's an open case. It's also my understanding that Mr. Franklin has been reaching out to Ms. Streeter, not the other way around. And again, this was a situation where it was his understanding that he can come to the house to obtain his property, so that he can, I guess, officially leave the residence. Based on all of that, Your Honor, we would ask for a signature bond in this case. My client has a very nominal income. She works as a receptionist tech at CSL Plasma. She works about 40 hours a week at $13.50 per hour. If you factor the fact that she's doing that, she's the primary caregiver of a 10-year-old. You know, obviously just normal expenses, everyday expenses, that doesn't leave much room for posting a high bond. So based on all of that, Your Honor, we would ask for a signature bond. If Your Honor is not amenable to doing that, we would ask for a bond of no more than $500, a surety bond no more than $500.
Thank you, Ms. Watson Cafe. I want to clarify the address again. What is the address, Ms. Arnold, that you all have for the victim at this time?
Yes, Your Honor. So I just took a look at the police report once more, and it shows that both the defendant and the victim are living at that address. So it's showing that both of them live at the 62 Harwell. So, Your Honor, we do not want to put our victim out on the street. So we are still requesting the stay away from that incident location. And we do just want to reiterate, Your Honor, that the defendant was under a previous bond condition to have no further contact with Mr. Xavier Franklin. So we just want to make that note that that is the defendant's responsibility to stay away from him. So again, we are asking to stay away from that incident location, and again, no further contact with Mr. Franklin.
All right, Ms. Watson Cafe, any response?
I'd just like to reiterate the fact that this was not a situation where she reached out to the alleged victim. This is a situation where he showed up at her house. And again, vehemently denies ever assaulting him physically. And he, again, did not want to press charges. I think that's consistent with that.
And the information you have is that he lives there as well, Ms. Watson Cafe?
No, the
With
information I
her?
have is he does not live there. That's why he was picking up his items.
All right. Here's what I am going to do.
Oh, and one more
Um,
thing, Your Honor.
yes.
She is the primary caregiver, so if you of a 10-year-old that she shares with the alleged victim. So it's not simply that you'd be putting out Ms. Streeter, but you'd also be putting out a 10-year-old. A 10-year-old would be required to move as well.
Right, I understand that. Thank you, Ms.
Your Honor,
Watson Cafe.
if I may.
Very briefly, Ms. Arnold, I think I have a clear picture of the situation, but go ahead.
Okay, I would just to that point though, I would just like to say if they share this child, I don't think that it would be that we would be putting out the 10-year-old as well. They share this child together, so they both share responsibility, Your Honor.
Is the victim present on this? I forgot the sound for him. Is the victim present on the screen?
I did not see him and we were
I
not
don't see
able
him
to
either.
make contact. So unfortunately, that's why we don't have a clear answer except for what's on the incident report. And it shows that that is his address as well.
Okay, thank you. All right, at this time, Ms. Streeter is going to receive a $2,500 surety bond. She is to have no further contact with the victim, last name Franklin. She may return to 62 Harwell Road so long as the victim is not currently residing in that location. If he is residing in that location, she must stay away from that particular address, such that she does not violate the no contact order. She is to have no weapons, drugs, or alcohol as a condition of this bond. All right, is there any further questions from either party regarding this ruling?
Nothing,
No,
from
Your
the
Honor.
Your Honor.
All right, and she will also be reset to the SAP calendar on March the 1st, whereby all of that can be revisited.
Your Honor,
Yes.
I do apologize. Could we, just for the sake of making sure that our victim is safe, could we have it be that there's a one-time police escort to determine that the victim is not there so that we don't have any other incidents?
If the victim is residing in that location, yes, she must return to her home with a police escort the first time to assure that the victim is not there. If the victim is there, she must collect her items and stay away from that location.
Thank you, Your Honor.
All right, is there anything further?
No, Your Honor.
All right, best of luck to you, Ms. Streeter.
Thank you.
All right, who do we have next?
Your Honor. Oh, I'm sorry.
Ms.
May I
Watson
be
Cafe, is
excused?
that your, yes, that's
Yeah.
completes your business. Have a great
Yes,
afternoon. Take care.
Thank you. You too.
Okay, bye-bye. All right, who do we have next?
The other Jordan.
Okay, this is position 7. All right,
And Judge, I'm gonna request a breakout room for this one.
okay. Oh, actually, this is position 6, Dwight Jordan. All right, if we could be placed in a breakout, please.
Thank you, everyone.
And who do you want in the breakout room? Besides you,
It's me, Miss Armstrong, I'm assuming Miss Falk and Miss Arnold.
May I please join as well, ma'am?
Who else?
Oh, I don't,
Oh, Ms. Kim?
and
Yes,
Miss Kim.
please.
Okay, all right.
Thank you, Your Honor.
No objection to that. Please put us in that breakout.
You seen it? You seen it? Yeah, we're not on mute, right? Yeah, too.
Having heard from the state on defense and the breakout, at this time, I want to sound for the victim. Ms. Arnold, will you please give me the victim's name again? I have Keith. I did not write down the last name.
Grant, Your Honor.
Oh, Mr. Grant, I'm sounding for a Keith Grant at this time. If you are present on the Zoom conference, Mr. Grant, this is your opportunity to make a statement to the court. I do not see that Mr. Grant is present on the screen. Ms. Armstrong is, actually, Ms. Arnold, let's go to you first. Will you just put the state's recommendation on the record?
Yes, Your Honor.
Without note to any of the facts discussed in breakout.
Yes, Your Honor. So the state is requesting a $4,000 surety, no further contact with Mr. Keith Grant, a stay away from 150 10th Street Northeast in Atlanta, a one-day anger awareness course, no drugs, alcohol, or weapons, and an MH.
All right, thank you. Ms. Armstrong, please put the defense recommendation on the record.
I'm sorry, Judge. Technical difficulty. Oh my gosh.
What case is this?
We're on position 6, Dwight Jordan.
My apologies. I'm back.
Okay. Ms. Armstrong, will you please put the defense's recommendation on the record?
Yes, Judge, we're asking Your Honor to consider a seizure bond in this matter. And if not that, then a bond no more than $1,000 given my client's indigency and mental health concerns.
Great, thank you. At this time, Ms. Armstrong, did you want to question your client very briefly?
Yes, Mr. Jordan, could you describe the nature of the housing that you live in at the 10th Street location?
Like government assistant houses. We lived in the same unit, and it was at a Super Bowl event we had for the apartment complex, and he brought out his personal remote control and changed the television.
Okay, Mr. Jordan, we don't want you to talk about what happened.
Oh, okay.
We just want you to tell us tell us about the facility in which you live.
I live in the same facility with him. I live on the 11th floor. He lives on the 12th floor in the same apartment unit building. And we pass each other and stuff like that. Like the other day I passed him and we spoke and that was it. You know what I'm saying? We passed security, I'll go in and we go in, out past each other. We live in the same apartment building. But
I understand. Thank you, Mr. Jordan. I don't want you to say anything else. I think I've got a clear picture of the facility. Is there anything further from either party before I issue my ruling?
No, I just say to myself, just stay in my units and go about my business. Don't say nothing to him. Just stay out of his way. No contact with him or nothing.
Okay. Thank you, Mr. Jordan. Ms. Arnold or Ms. Armstrong, is Ms. Armstrong still present?
Yes, Judge.
Okay, you disappeared for a moment. Is there anything from either party regarding this case before I issue my decision?
No,
Nothing
Judge.
on the state, Your Honor.
Okay, at this time, Mr. Jordan is going to receive $1,000 surety bond. He is to have no further contact with the victim, last name Grant. What that means, Mr. Jordan, is if you see Mr. Grant in the hallway, you turn around and you go in the other direction. You are to stay at least 1,000 yards away from him at all times. That's 2 football fields. I am not going to issue the stay away, having heard that they live on different floors. Mr. Jordan, my strong advice to you is to stay on your floor and then go directly out of the building until your case is resolved. He is to have no weapons, drugs, or alcohol as a condition of this bond.
Yes, ma'am.
Drugs unless prescribed.
Unless prescribed, he can take all prescription medication, none without a prescription.
Yes, ma'am.
All right, is there anything further from either party?
No, Your Honor.
No, Judge.
All right, best of luck to you, Mr. Jordan.
Thank you.
We can move to the next position.
Number 12, Mr. Rainwater.
Okay. Are you Delon Rainwater?
Yes, ma'am.
Okay, your case is 22 CR 000791F. in which you're charged with 1 count of pedestrian in a roadway and 1 count of obstruction of a law enforcement officer, each with offense dates of February the 15th of 2022. You've heard me advise you of your right to remain silent and your right to an attorney. As you can see, I'm on video, and so is your attorney, Ms. Kim. Do you object to that?
No, ma'am.
Thank you, Mr. Howard.
52 total. Last arrest was 2020, probation violation. He has a lot of FTAs and probation violations in this issue. Open case in Superior Court for 2 counts of shoplifting, possession of cocaine, and possession of marijuana. It's 20 SC 174214.
Okay, thank you. Whose case is this? Is this yours, Ms. Arnold?
Yes, Your Honor.
And the state's recommendation?
Yeah, so there is currently a bond for count 1 for pedestrian in the roadway. It's set at $500. We would ask that that remain. And for count 2 for the obstruction, we are asking for a $2,000 surety bond, which would make a total $2,500 surety bond. No further contact with Officer Duncan and no drugs, alcohol, or weapons. Your Honor, this incident happened yesterday at 1980 Delowe Drive in Atlanta. Delowe spelled DELOWE. The defendant was observed illegally stepping in the roadway and crossing the street. Once Officer Duncan stopped the defendant and ran his information, it came back that the defendant was wanted out of Fulton County for a failure to appear on possession of cocaine. When Officer Duncan attempted to place the defendant in handcuffs, the defendant fled on foot into the woods. Before being apprehended, the defendant refused to walk out of the woods, and the fire department had to actually come and hook him to a flatboard and pull him out. We do believe that the defendant will reoffend. As pretrial has already stated, the defendant has 52 cycles of criminal history. I'll only go through the last 10 years. The defendant has probation violations from 2013, 2015, April of 2016, November of 2016, and from 2020. He also has FTAs. So we do believe he is a flight risk as well from December of 2014 and October of 2019. Your Honor, the defendant has also been convicted. He has a 2013 conviction for possession of a firearm by a convicted felon, obstruction of a law enforcement officer. And then in 2014, he had a conviction for fleeing or attempting to elude a police officer, discharge of a firearm on or near a public highway, pointing and aiming a gun or pistol at another. In 2015, he also had a conviction for driving without a valid license, DUI, driving under the influence of multiple substances, and an obstruction charge. And as I have mentioned in the facts, the defendant currently has an open case for the possession of cocaine and possession of marijuana less than an ounce. With that case number being 20 SC 174214. So we do believe, Your Honor, based on his history and on that open case, that he will reoffend. And we are concerned that he is a flight risk, considering he was arrested after officers saw he had a warrant for this open case. So we don't believe that he will return to court. So we are requesting that $2,500 surety with the conditions as stated. Thank you.
Thank you. Ms. Kim?
Yes, Your Honor. Mr. Rainwater is 44 years old, and he has been here in Georgia a long time. And he has 3 children that he has to support, 14, 12, 11. He has been working as a construction machine operator for the last 8 years. And even though he earns money, he cannot pay for significant bonds at this point. So we would like to request for a signature bond. If not, very low surety bond because of his past history, but those histories are mostly long time ago. It's kind of like 2019 or over. He was actually that area. He cannot stay away from that location because that's the bus stop where he takes transportation to go to work. So if he cannot go that area, he does not have any other transportation method to go to work and become productive member of the society. So we would like to request that stay away only if he does not ride a bus there. So, and that's it, Your Honor. So please consider his indigency and give him surety signature bond, Your Honor.
Thank you, Ms. Kim. At this time, he is going to receive a $500 surety. The $500 surety that is in place on the pedestrian and roadway will remain on the obstruction. He will receive another $500 surety bond for a total of $1,000 surety bond. He is to have no further contact with the victim, last name Duncan, and he is to have no weapons, drugs, or alcohol as a condition of this bond.
Thank you, Your Honor.
All right, is there anything further from either party? If not, best of luck to you, Mr. Rainwater.
Everybody.
All right, we can move to the next case.
Number 16, Mr. Tillery.
Okay, good afternoon. Are you Khalid Tillery?
Yes, ma'am.
Your case is 22 CR 00790G, and what you're charged is 1 count of battery family violence and 1 count of cruelty to children in the 3rd degree with an offense date of February the 15th. You've heard me advise you of your constitutional rights. Do you object to a video hearing?
I do not.
Do you object to your attorney assisting you by video?
No, ma'am.
Thank you. Mr. Howard?
I got 12 total. Last arrest was April 2021. Simple battery. He's on probation for false imprisonment, 2 counts of ag assault a deadly weapon. In 2014, they gave him 2 years, 6 months confined, and then 7 years, 6 months probation. He's out on pretrial for simple battery family violence. It's 21 CR 001-945Y. That's an $8,000 bond. And he got bench warrant for the felony charges.
All right, thank you. Ms. Arnold?
Yes, Your Honor. The state is requesting a $10,000 surety bond for count 1 for the battery family violence and a $2,000 surety bond for count 2 for cruelty to children for a total of a $12,000 surety bond. We are also asking that there be no further contact with Miss Mccluster Tillery. Mccluster spelled Mikiea, Tillery spelled Tillery, or the minor child initials AW. We're also asking for a stay away from 1847 Childress Drive, spelled CHILDRESS, Southwest in Atlanta. 1-day anger awareness and no drugs, alcohol, or weapons. Your Honor, this incident happened just yesterday at that Childress location. Officers were dispatched after receiving a request from Miss Tillery's mother, Glenda Edie, last name spelled EADDY, to perform a welfare check on her daughter. And that was after she received a phone call from her granddaughter, AW, that the defendant had abused her mother. When officers arrived, they did initially attempt to speak with Miss Tillery and to see, what was going on, but the defendant interrupted and told officers that Miss Tillery was jumped by some women that she had confronted about his infidelity or cheating. Officers quickly cut the defendant off and detained him so that they could separate him from Miss Tillery and get her side of the story. Once the defendant was separated from her, Miss Tillery was able to give account of what happened, where she stated that the defendant was cheating on her and she had found that out. And so she was texting some of the females through her phone. Around 2 a.m. that night, the defendant went through her phone and saw that she had been texting other females about his cheating, which infuriated him. So she woke up to him punching her in the face. And again, that was around 2 a.m. She told officers that she is in fear of her life and didn't want to give any more information. So at that point, officers stepped away and went and spoke with the defendant, who stuck to his story that Miss Tillery was jumped by some women. And then they came back again to Miss Tillery and said that they, got some more information about what had happened. At that point, she advised that the defendant actually struck her multiple times in the face. And that morning after she got up, she took her kids to school. And when she returned around 9 a.m., the defendant began to hit her again in her face and in her head with his fist. When officers were able to speak with Ms. Tillery's daughter, AW, she told them that she was able to hear her mother getting hit by the defendant, which is why she called her grandmother that morning before school. AW also informed the officers that that abuse had been going on for the past 5 years. And every time the defendant gets caught cheating, his mother ends up getting hit. Officers made note that Ms. Tillery suffered multiple lacerations on her face, swelling to both sides of her neck and cheek, swelling to both sides of her cheekbone area, my apologies, and a blood clot in her left eye. Your Honor, we do believe that the defendant will reoffend based on the fact that he has an open case against this same victim that pretrial has already given you the case number for. That is the open case for the simple battery from April of 2021. That case is also against Ms. Tillery. Her name was Edie at the time, but that is the same victim. So we do believe he will reoffend based on the fact that he has that open case. And as pretrial stated, he was released on an $8,000 SOB through pretrial and ordered no further contact with the victim and a stay away. However, we're back here again on another battery, family violence, and cruelty to children against the same victim. Your Honor, additionally, we not only believe that the defendant is a danger to a victim in this case, but a danger to society in general. Much of his history is very violent. He has a 2006 arrest for battery, a 2013 arrest for kidnapping and aggravated battery, and then an arrest from April of 2021 for simple battery. And then he has convictions from August 2009. He was arrested for participation. Participation in a criminal street gang, aggravated assault, possession of a firearm during commission of a felony, carrying a concealed weapon, possession of marijuana less than 1 ounce, obstruction and reckless conduct. And he was convicted of those charges for carrying a concealed weapon, obstruction, and reckless conduct. In 2013, he was arrested once more for participation in a criminal street gang, kidnapping, false imprisonment, 3 counts of aggravated assault, 2 counts of aggravated battery, aggravated assault with a deadly weapon. And he was convicted from those charges for false imprisonment, 2 counts of aggravated assault, and aggravated assault with a deadly weapon. So, Your Honor, we are very concerned for the safety of the community, as well as our victim, who told officers that she was in fear for her life. And so, Your Honor, we are asking for that $12,000 surety bond based upon those facts and his history, and that with the conditions as stated, that there be no further contact with Ms. Tillery and a stay away from that location as well, Your Honor. Thank you.
All right, thank you so much, Ms. Arnold. Ms. Kim.
Yes, Ms. Tillery is 33 years old, and he has been a resident of Georgia for the last 33 years. He has 3 children. 2 of them are 9 years old, and 1 of them is 10 years old. And he's the one who has to take care of those 3 children. He has to provide financially. And he's been gainfully employed as a construction supervisor for the last 10 years. He graduated from high school. Even though he didn't go to college, he has been working diligently. And we do not object to stay away, no further contact, no drug, alcohol, weapon, 1 day anger or awareness classes. All those, we are fine with it, except that we need 1 time visit with a law enforcement officer just to get personal belongings. If not, he is willing to make an arrangement to get them through third party. However, $12,000 surety bond is way too much for a father who has to take care of 3 children. So we would like to request for a lower surety bond, about $2,000. Thank you, Your Honor.
All right, thank you so much. At this time, Mr. Tillery is going to receive a $2,000 surety bond for count 1, the cruelty to children, and a $5,000 surety bond for count 2, the battery, family violence, for a total of a $7,000 surety bond. He is to have no further contact with the victim, last name Tillery, or the minor child AW. He can return to the Childress location one time with a member of law enforcement to get any items. Otherwise, he is to stay away from that location, and he is to have no weapons, drugs, or alcohol as a condition of his bond. Is there anything further from either party?
No, Your
No,
Honor.
Your Honor.
All right, best of luck to you, Mr. Tillery. We can move to the next position.
Thank you. Thank you, Your Honor.
This is 8, 9, and 10, Mr. Lowe.
Our positions 8, 9, and 10. I guess we'll take them all at once. Good afternoon, Mr. Lowe. Your cases, you have 3 cases. Your first case is 22 CR 0000796J with an offense date of September the 19th of 2021, in which you're charged with simple battery against either a pregnant person or someone who is over 65. Your second case is 22 CR 0000797J, in which you're charged with battery against the female who was pregnant with an offense date of December the 10th of 2021. And finally, your case 22 CR 0000798J, in which you're charged with battery family violence with an offense date of December the 29th of 2021. You've heard me advise you of your right to remain silent and your right to an attorney. Do you object to a video hearing or to Ms. Kim assisting you by video?
Your Honor, this is actually Ms. Armstrong's case.
Oh, or Ms. Armstrong, I apologize, Ms. Armstrong assisting you by video. Do you object?
What do that mean again?
What that means is I'm conducting this hearing by video. Do you object to a video hearing for us to give you a bond today?
No, ma'am.
Thank you. All right, Mr. Howard.
His second arrest. Last arrest was Monday, possession of marijuana. He went to the city jail for that.
Okay, thank you. Is it Ms. Guidry?
Yes, Your Honor, it's my case.
Okay, Ms. Guidry, your recommendation for
Okay.
each case?
Yes, I was just about to say that I'm gonna go over each case, the facts, the recommendation for each one like that. So for position 8, ending in 796J, we're recommending a $4,000 surety, $3,500 for the simple battery against a person who's pregnant, and $500 for the criminal trespass. No further contact with Patriana, that is Patrianna, Bartley, common spelling. Stay away from 532 Cleveland Avenue Southwest, the entire apartment complex. Third-party contact with children, 1-day anger awareness, and no alcohol, drugs, or weapons. In this case, Your Honor, officers responded to the location. Ms. Bartley, who was 3 months pregnant at the time, stated that the defendant kicked in her front door, which was locked due to the defendant being irate. He walked into Ms. Bartley's room, closed the door, and began to threaten her with a pocket knife in one hand and a screwdriver in the other hand. He then began to punch her until her brother overheard them and pushed them apart. The defendant then ran downstairs, grabbed a large rock, and threw it into the windshield of Ms. Bartley's vehicle. Ms. Bartley at this time did not sustain injuries. However, she was slumped over, breathing heavy, and complained of stomach pains. At the time of this incident, the parties did live together. The second incident, position number 9, ending in 797J, at the same incident location, we're asking for a $5,000 surety bond, no further contact with the victim, stay away, third-party contact, 1-day anger awareness, and no alcohol, drugs, or weapons. Your Honor, this incident occurred on December 10th. They spoke again to Ms. Bartley, who stated that she and the defendant got into a verbal dispute and she was trying to leave the apartment. She states that the defendant held her against her will and would not let her leave. The suspect then slapped her in the face, kicked her in the stomach, and dragged her across the floor. At this time, she was 6 months pregnant. Ms. Bartley sustained swelling to the left side of her face. In the third case, Your Honor, 19 days later, December 29th, at the same incident location with the same victim, we're asking for a $6,000 surety bond with the same conditions, no further contact, a stay away, third-party contact with the children, 1-day anger awareness, and no alcohol, drugs, or weapons. Again, they responded to the same location. They spoke to Ms. Bartley again. She stated that she was walking outside of her apartment when she saw the defendant, and she started to move very quickly to get back to her apartment. At this time, she had a boot on her left foot, which resulted from a previous assault from the defendant again. When she finally made it to her apartment, the defendant bum rushed through the front door, pushing his way in. Once inside, the defendant asked why Ms. Bartley was not answering his phone calls. She told him that she did not want to fight and she asked him to leave. A scuffle started where the defendant bit Ms. Bartley several times on her left arm. In defense, Ms. Bartley retrieved a kitchen knife and stabbed the defendant in the stomach region. The defendant immediately punched Ms. Bartley in the mouth after being stabbed and fled the scene. Ms. Bartley sustained a cut and swelling to her upper lip and 2 bite marks to her bicep. The parties do have children together, and after speaking with Ms. Bartley, we learned today that she was still pregnant at this time again. Your Honor, we are gravely concerned for the victim's safety in this case. 3 cases spanning over a 3-month period of time. The defendant continues to show up at the same residence and harass her. The last time he was not invited, he found her while she was walking. We are very concerned for her safety, her children's safety. He's a danger to the community. He's a danger to her. And if we do not set a surety bond in this case, Your Honor, we may be back here for a very serious incident. So that's why we're asking for the stated recommendations in all 3 cases.
All right, thank you. Ms. Armstrong? Ms. Armstrong, if you're speaking, you're muted. We can't hear you.
Thank you so much. I apologize. As I said, Mr. Lowe, he's 20 years old. He is originally from the Atlanta area. He is not a flight risk. He works in the construction industry. And if I'm correct, he has no criminal history, or at least much of one to speak of. And because of the lack of criminal history, we are asking Your Honor to take that in consideration with the defense's recommendation for no more than $2,000 in total for position 8. For position 9, once again, no more than $2,000. And then for position 10, also no more than $2,000, which would be a total of $6,000. That is appropriate given my client's lack of criminal history. It is also appropriate because my client is indigent. And quite frankly, it would be better served for the child that my client reports having just had to be earning money to support the child. It is obvious that there needs to be a no contact provision in this matter. We would ask for third-party transfer of any children at issue. And also we would welcome to stay away from the location. Essentially, we're asking Your Honor to set a reasonable bond considering my client's criminal history, his indigency, lack of flight risk, but also recognizing that there may need to be conditions put in place.
All right, thank you. All right, at this time for position 8 ending in case number 796J, Mr. Lowe is going to receive a $4,000 surety bond. It'll be $3,500 for the civil battery and $500 for the criminal trespass. He is to have no contact with the victim. He must stay away from the incident location, no weapons, drugs, or alcohol. For position number 9, Mr. Lowe will receive a $2,500 surety bond. He is to have, with the same conditions, no weapons, drugs, or alcohol, third-party contact with his children, and he must stay away from the victim. And he must have no further contact with the victim and stay away from the incident location. As to position 10, he's going to receive a $3,500 surety bond. He is to have no further contact with the victim. He is to stay away from the incident location and arrange transport of the children through a third party. If he has any items there, he can return one time with a member of law enforcement to get any possessions he may still have there. And he is to have no weapons, drugs, or alcohol. Are there any questions or any conditions that I have not addressed as part of these 3 cases?
No, Your Honor.
All right. Hearing none, best of luck to you, Mr. Lowe. All right, who do we have next?
Number 13, Mr. Roberts.
Okay. Good afternoon, Mr. Roberts. Your case is 22 CR 000-788C, in which you're charged with 1 count of battery family violence with an offense date of January the 12th of 2022. You've heard me advise you of your right to remain silent and your right to an attorney. Do you object to a video hearing today?
No, ma'am.
Thank you. Do you object to your attorney assisting you by video?
No, ma'am.
Ms. Kim, are you his attorney?
Yes, Your Honor.
Okay, just clarifying that point. Mr. Howard, I see that he is recommended for pretrial services, first arrest.
Second,
Second.
he was arrested Sunday for suspended license. That's all.
Okay. Thank you. All right, Miss, is it Miss Arnold again? Miss Arnold, your recommendation?
Yes, Your Honor. The state is recommending a $4,500 surety bond for battery family violence. No further contact with Destiny Dixon, all spelled traditionally. 1 day anger awareness, no drugs, alcohol, or weapons. Your Honor, this incident happened on January 12th of this year at 694 Quaker Street, Southwest in Atlanta. Ms. Dixon advised that she went over to her boyfriend's house, a person whom she used to live with, and the defendant in this case, to confront him about an Instagram picture. Ms. Dixon refused to let it go, and this caused the defendant to get extremely upset. When Ms. Dixon advised that she was going to leave, the defendant punched her in the face so hard that he broke off one of her brackets from her braces, Your Honor. Ms. Dixon also had some swelling to her face. However, that is not where the incident stopped. After that, the defendant struck Ms. Dixon. After he struck Ms. Dixon, I do apologize. The defendant proceeded to drag Ms. Dixon out of the house and then took her phone and threw it. Your Honor, based on the facts of this case where the defendant struck her so hard that he broke her braces and then dragged her out of the home, we are requesting that $4,500 surety bond with the conditions as stated. We did speak with the victim, and she stated that she does not fear the defendant, and that they do share a child as well. But we are still requesting no contact, Your Honor. This only happened on the 12th, so we are concerned about her safety. So we would still be asking that there be no further contact. And for these reasons, we are also requesting the $4,500 bond, Your Honor. Thank you.
I'm sorry, what was that stay away location again?
I just meant, I should have said no further contact. We're not requesting to stay away. From what we
Okay.
could tell in the report, they don't live together.
Okay, thank you. I wanted to clarify that point. Thank you. Ms. Kim?
Yes, Your Honor. We would like to request for a signature bond because this is his first violence allegation. He is only 24 years old, and it was his place, his house. Complaining witness came to his house without invitation, and he was basically protecting his own property, and he has a right to do so for his place. And he has 3-year-old son that he has to take care of, and he's right now working as a loader for the truck. So he really needs to make money to take care of his son and also himself. He graduated from high school. He could not go to college, even though he wanted to. He was admitted to Metropolitan College. However, he has his son, so he has to work to support him. He actually has 2 jobs, one as a truck loader and the other one custodian at DeKalb County School Elementary School. So we would like to request for the low bond, actually signature bond, because he really is qualified for a signature bond as a first being alleged here. Thank you.
All right, thank you. I see the victim last name Dixon is present on the screen. Ms. Dixon, if you would like to make a statement, you're not required to do so, but if you wish to, this is your opportunity. I need you to turn on your camera and unmute if you would like to tell the court something. Would you like to make a statement at this time?
Yes.
Okay, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge?
Yes.
All right, what would you like to tell me today?
I would like to say that I do not fear Christopher Roberts, and if we can do a no violent contact, but we can contact each other on the state file sign.
All right. Thank you, Ms. Dixon. I appreciate you making that statement to the court. Because I allowed Ms. Dixon to speak, is there anything further from either party before I issue my ruling?
No, Your Honor.
Okay. Thank you. At this time, Mr. Roberts is going to receive a $2,000 surety bond. He is to have no further contact with the victim, last name Dixon. He is to have no weapons, drugs, or alcohol. He can arrange transport of his child through a third party. And his case will also be reset to the SAP calendar on March the 1st, whereby that can be revisited at this time. Is there anything further from either party?
No, Your Honor.
All right. If not, that concludes his case. Best of luck to you, Mr. Roberts.
Thank you, Your Honor.
All right. Does that complete the entire calendar? I believe it does. I
Your
don't see-
Honor,
Your Honor,
Go
I
ahead.
do have one more.
Okay.
Who else? 'Cause I'm out of paperwork. Is it William?
Yes.
Oh, he here?
Okay, yeah. I do see position 17, Williams. Is there an announcement, or because I don't see him in courtroom 2, or do you intend to waive his appearance?
Yes,
Ms. Kim?
waive his appearance. Yes, Your Honor.
Okay, you'll please submit your waiver of arraignment. Mr. Howard, do you have his history?
13 total. Man. Fade to appear from 2021. Last arrest was August 2021. Fade to appear, battery, family violence. He's out on pretrial for battery. That's $5,000 bond. Case number 20 CR005 480Y. Another battery 21 CR002 613Y. He got history out of Indiana, 2011, theft, escape, unauthorized use of a motor vehicle. That's a conviction. So he got plenty of violence. And I'm about to come off of this other bond.
Okay, thank you. All right, Ms. Arnold.
Yes, Your Honor. The state is requesting a $5,000 surety bond for the criminal trespass. A stay, excuse me, a stay away from 3548 Atlanta Street, apartment C in College Park. No further contact with Ayanda Barnett. Ayanda spelled Ayanda, Barnett spelled Barnett, and no drugs, alcohol, or weapons. Your Honor, this incident happened on January 23rd of this year at the Atlanta Street location. Ms. Ayanda Barnett advised that her husband, the defendant in this case, kicked in her front door, damaging the lock plate, causing damages of approximately $50. Your Honor, we are concerned that the defendant will reoffend, and we are asking for that $5,000 surety based on the fact that those two open cases that pretrial mentioned are against this same victim, the simple battery and the battery family violence. In the simple battery, he was given a $5,000 signature bond from Judge Law. He was supposed to stay away from the victim as well as the Atlanta Street location. And then for that battery family violence, he was given a $3,000 good bond from Judge Morrow, and also told to have no further contact with the victim and to stay away from that address. But he went back again on January 23rd of this year. In addition, we are concerned that he will be a flight risk as he has a recent failure to appear from 2021. So for these reasons, Your Honor, we are asking for the $5,000 surety with the conditions as stated. Thank you.
Thank you. I see the victim is present on the screen, last name Barnett. If you would like to make a statement, this is your opportunity to do so. I need you to unmute your screen. Would you like to make a statement, Ms. Barnett? You're not required to do so.
Yes.
Okay, please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge?
Yes.
All right, what would you like to tell me today?
Can you hear me?
Yes, I can hear you. What would you like to tell me today?
Yes, I would like for my husband to get out of jail. We have had our disagreements, but I do love him and I am not afraid of him. He has not been living here. He did come by that day and the incident did happen because he did let me know that he was coming by earlier and I know that he was upset. So things happen, but we are married and we do plan on staying married and working things out. And he has been sick in the jail, as well as I would like for him to get out of jail, because he does have a job and he does still provide for me financially. But he does have limited resources because he hasn't been to work in over a week.
Okay.
And I would like to drop the charges. I am not pressing any charges.
All right, thank you, Ms. Barnett. I appreciate that. All right, Ms. Kim.
Yes, Your Honor. Mr. Williams is 31 years old and he is working at aquarium and he has been working there for 1 year and he really, really want to keep this job because, as Ms. Burnett addressed, he is the sole breadwinner for his family. So we would like to request that, and I don't think that he is a flight risk. He was born and raised here in Georgia and he went to college, Georgia State University, studying economics, and he still want to continue to get the bachelor's degree in near future. And we would like to request for low surety bond of $500, Your Honor. Thank you.
Thank you. At this time, Mr. Williams is going to receive a $1,500 surety bond. He is to have no further contact with the victim at this time. He'll be reset to that SAP calendar on the 1st where that can be revisited. He is to have no weapons, drugs, or alcohol as a condition of his bond. And he must also stay away from the incident location. Is there anything further at this time from either party?
No, Your Honor.
No, Your Honor.
All right, best of luck to that defendant. I believe that does conclude our calendar.
Thank you, Your Honor.
Do we want to review?
Oh,
Yes.
My apologies for interrupting. Yes, we would like to go over the calendar, but I just wanted to ask, going forward, if the PD's office could go ahead and file any notice of waiver prior to court. The DA's office, my apologies, the SG's office normally requires a filing with the clerk before we have the hearing. So we would just ask going forward, so that we aren't in the position where we're going to have to object to it, that filing be done before court.
Got it. Yes,
Thank
Your
you.
Honor. Yes.
All right, Ms. Champion, will you review the calendar for us, please?
Yes, ma'am.
Thank
Position
you.
number 1 is a total of a $6,000 pretrial bond, reset for the notice. Position number 2 is a $1,000 good bond, reset to the SAP 3-1. Position number 3 is reset to the C tomorrow at 2/17. Position number 4 is a total of a $10,000 split bond, $5,000 pretrial, $5,000 good bond, reset SAP 3-1. Position number 5 is reset to the C calendar 2/17. Position number 6 is a $1,000 good bond, reset SAP 3-1. Position number 7 is the $5,000 SOB through the jail, reset for the notice. Position number 8 is a total of a $4,000 good bond, reset SAP 3-1. Position number 9 is a $2,500 good bond, reset SAP 3-1. Position number 10 is a $3,500 good bond, reset SAP 3-1. Position number 11 is a total of a $2,500 good bond, reset SAP 3-1. Position number 12 is a total of a $1,000 good bond, reset SAP 3-1. Position number 13 is a $3,000 good bond, reset SAP 3-1. Position number 14 is a total of a $225.04 good bond, reset SAP 3-1. Position number 15 is a $2,500 good bond, reset SAP 3-1. Position number 16 is a total of a $7,000 good bond, reset SAP 3-1. Position number 17, defendant waive appearance, is a total of a $1,500 good bond, reset SAP 3-1.
Good job. Good job.
Any comments, changes, corrections, or questions?
I do have a question about waiver of appearance, since it's the defendant's right to waive their appearance. I don't understand the state's position that they could object to it, just with reference to their.
I would love if you all would address that perhaps with each other outside, and maybe come to some type of concurrence. It is my understanding that it should be filed beforehand, but I know that that's not always practical, and I know it's not always possible. especially with COVID and quarantines in the jail. I know that that's been difficult at times. So if we could work together to come up with a creative solution, I would appreciate it. If there are any other issues, I ask that you all try to work together on those. If not, we'll be in recess until tomorrow at 2 p.m. All right, is there anything further from anyone else?
You
That
back
is
Friday,
okay.
right?
I do have one question, Your Honor. I apologize. For position 13, I think that the surety bond was stated at a $3,000 surety. I had a $2,000, so I just want to clarify.
I got 2,000.
What did I write?
I'm sorry, it is a 2,000. I'm sorry.
It's 2,000.
Okay, thank you.